Hello, so welcome back to my law channel. We're carrying on with pure economic loss and negligent statements. Now I'm going to look at reliance by a third party on these statements which turn out to be negligent. So someone who relied on this might not be the one who suffered loss. It might be somebody else who suffers loss as a result of the negligent statement. There's Ministry of Housing and Sharp, 1970. Spring against Guardian Assurance Limited, 1995, is a similar case. In that latter case, someone wrote a reference about a former employee who was trying to get a job and was found to have a duty of care not only to the prospective employer who relied on it. So bear in mind the defendant was obliged through these rules about the regulation of the financial institutions to provide a reference. The reference was supplied by the defendant and it was very harshly critical, and it falsely said that the plaintiff was dishonest. And so the plaintiff there suffered real financial loss because he was unable to secure a job. Even though the reference was a defamation, the plaintiff would not have succeeded in a defamation action because, as there was no malice, it was only an honest mistake. The defendant would not have been able to prove a defence of qualified privilege. So the defendant would have been able to show qualified privilege. The plaintiff then took an action of negligence, and the plaintiff's line of reasoning was this: that giving cause of action negligence would distort and subvert the tort of defamation. That was the defendant's argument. If the plaintiff won, then employers would worry about liability and then be thought loath to provide references and supply really any anodyne ones which were worthless. The House of Lords held that preserving the law of defamation would not be enough to deny the plaintiff relief, and therefore the defendant was found liable. So majority of them found this. Lord Keith dissented, and he said that they thought that the two torts were different. Defamation is there to defend a person's reputation, but a negligent reference can harm someone without affecting that person's reputation. So in Mackay against Swindon College 2011, an unsolicited email, not a reference, was sent, and it contained information which was largely false and mistaken. It was sent by a former employer of a lecturer, and that led to the person losing his job. Even though the email was not a reference, the Caparo test was found to be applicable, and the defendant was nevertheless held liable for a negligent statement. So how about economic loss in performance of service? The Headley Byrne case was long regarded as being about advice or information which a claimant relied on. It was then found that it had to be interpreted more broadly, and the Headley Byrne principle was extended. So a defendant can be liable where there's been a voluntary assumption of responsibility by the defendant to a claimant or to other people as part of some transaction. So on this interpretation, liability for negligent misstatements is simply an example of the broader principle that reliance is not an essential ingredient of liability. In Henderson and Merit Syndicates Limited 1995, many cases coming out of the near collapse of Lloyd's of London insurance market were taken by syndicates or names as they're known. So there was negligence on the part of the agents who'd organised these syndicates. So it's about 1992, these insurance underwriters, they almost went bust. The agents said the position with the names should be governed by terms of contracts between parties and not by tort. This favoured some of the names because it was more advantageous to them, the limitation period in tort. The House of Lords felt the agents had assumed direct responsibility to the names, and the prima facie duty of care arose. So the sub-agents were acting on behalf of indirect Lloyd's names, owed a duty of care to names because they'd assumed this responsibility. The existence of a contract doesn't rule out liability in tort. The House of Lords found that assumption of responsibility can be the reason for recovering in tort if the defendant has accepted a professional task to perform. In Customs and Excise Commissioners against Barclays Bank, Lord Hoffman said, using this notion of assumption of responsibility in this case, while this is permissible, it is not so useful or illustrative. And this is what Lord Hoffman had to say. The question was not whether the defendant had assumed responsibility for the accuracy of the particular statement, but a much more general responsibility for the consequences of their conduct or the underwriting. To say that managing agents assumed responsibility to names to take care not to accept unreasonable risks is a little different from saying that a manufacturer of ginger beer assumes the responsibility to consumers to keep snails out of his bottles. Close quotations. Yeah. So he's saying the sort of Donahue and Stevenson principle is applicable here. So the extent of this principle was elucidated by Lord Stein in Williams and Natural Life Health Foods 1998. So the plaintiffs had signed a contract with the company to franchise a health food shop. The plaintiff's business was a flop, and they wanted to show that the defendant had personally assumed responsibility for the negligent advice given by the company. And this is subsequently, the company has subsequently gone out of business. Even though it was held in this case, the defendants had not personally assumed responsibility. Lord Stein said that the extended Hedley-Byrne principle, proven in Henderson, does not simply apply to negligent statements. It is also applicable in negligent performance services, and can even mean there's a tort duty which runs concurrent with a contract. So Henderson was found to be applicable in West Bromwich Albion Football Club against El Safdie 2006. There was a duty of care to a patient, was not accompanied by an assumption of a duty to a third party, not to occasion financial loss. In this case, the football club had brought an action against a surgeon for the financial losses the club had sustained when one of their players was negligently prescribed treatment by that surgeon. So the foreseeability and proximity was found to be there between the club and the consultant, because the club had paid for the medical care. The Caparo test was also found to have applicability. The Court of Appeal said it would not be fair, just and reasonable to impose a duty on the club on the basis that the duty would conflict with the doctor's main duty to care for his patient. His duties to the patient, not to the football club. So the ratio in Henderson was applicable in Burgess and Lejeune 2017. A claim in tort succeeded. The defendant had a special skill, and she had assumed responsibility for the advice and service that her friends were depending on. So this is a key instance of the extended Hedley-Byrne principle. You see it in White and Jones as well, 1995. The assumption of responsibility by a solicitor towards his clients was then found to extend to the beneficiary of the client's will, who, due to the solicitor's failure to execute the will prior to the client's death, were deprived of the legacy they were supposed to receive. The case is very notable because the claimant did not suffer loss, but simply didn't get the financial benefit that the testator had wished her to have. The chief ground for extending responsibility to the solicitor is otherwise there be no action that could be taken against a solicitor in this case. The estate had suffered no loss, but reliance on a statement by a claimant is not vital to establish a duty of care. Their lordships, as in the judges, they found that by accepting instructions to set up a will, a solicitor had come into a special relationship with those who were supposed to benefit by that will. And therefore, this meant there was a duty on the solicitor to act with expedition, as in reasonably quickly, and diligence on behalf of the beneficiaries of the will, so they could sue on it. There's another instance of the limited extent of this assumption of responsibility. You can see it in Gorham and British Telecommunications PLC 2000. The Court of Appeal upheld the White and Jones and said it's not restricted only to wills. So Mr. Gorham had sold his personal pension, and he wasn't advised that BT's occupational pension would be more advantageous to him. Even if he joined the B scheme when he was informed about it, would be better. His family would not have been entitled to pension because he would not have been a member of the scheme for 2 years by the time he died. They would have ever got a lump sum, and it was obvious that Mr. Gorham wanted to create a benefit for his dependent spouse and children, and the duty of care was owed to them by the insurance company. Okay, so they were liable. So there are obviously lots of slogans and practical guides about this, but I'll come on to this later.